Ready? I think we got one more. Okay. All right. Good afternoon, everyone, and thank you all for joining us for today's A Month of Service presentation of Wills and Advanced Legal Planning and Why Do You Need It? This is part one of our session for today. My name is Nia Murray. I am the programs coordinator with Neighborhood Recovery Community Development Corporation, and we are one of the partners in the A Month of Service collaboration. Also included, we have the City of Houston's Department of Neighborhoods. And on behalf of our presenting partner today, we have Lone Star Legal Aid. And presenting, we will have Ms. Jessie Campbell providing the information for you all today about advanced legal planning and why do you need it. But also included in our partnership, we also have the Earl Carl Institute, Texas Legal Services Center, Houston Volunteer Lawyers, Harris Central Appraisal District, and the Harris County Tax Assessor Collector's Office. And together we make up A Month of Service. And basically, A Month of Service is the collaboration of all of our organizations coming together on a monthly basis and offering a variety of different workshops, resources, information that we all pull together to try to get as much information out to the community as we possibly can. We decided to collaborate several years ago in an effort to make a larger impact, to reach more people, to try to get as much information as we can out there. So we decided to get together in a collective effort and to do just that. Unfortunately, we did have to convert to the virtual platform where we used to be out in person in a particular neighborhood for an entire month with all of the different workshops, and then go to another neighborhood and then do the same thing again. So we're slowly going to try to get back out there and do things and present on a hybrid basis. But for right now, this platform has definitely allowed us to reach and expand the offerings through of our collaborations. We speak to people that actually attend that are not just in the city of Houston and Harris County, but also surrounding counties and across the entire state of Texas, and even in some instances across the country that where they join in, because we do this session live on our social media platforms, as well as we record the session and post it on our various platforms as well. So we get people that view the information from all over. We know that there are a lot of people, a lot of underserved communities that are out there that do not have access to a lot of information, people that don't know where to go for particular resources, or when they have questions about the preservation of their assets. So anything related to asset preservation, the maintaining of generational wealth, asset building, and community empowerment is what we try to do in the information that we try to get out to community members such as yourself. So we've been doing this collaboration on this scale probably since just before COVID, 2018, 2019, or something to that effect. So for those folks that are continuing to follow us and refer people to us, we thank you very much for your continued support. For the folks that are new that are just joining us, we want to welcome you and thank you all for coming this afternoon. Listen, there's a lot of information that's going to be covered here today about advanced legal planning and why do you need it. Know that, again, this is kind of part one of our session, only because, again, there's a lot of this information that's going to be talked about. And Ms. Jessie's going to go over in all the details of how the two segments are broken down. But know that there's an opportunity for you to ask questions. I know that there were some questions that were emailed to me in advance, and I'll make sure that those get addressed too by Ms. Jessie at the end. In addition to that, you could feel free to type your question into the chat. She's really good about answering the questions as she moves along. We do ask that you try to keep your questions to be as general as you possibly can. And one, not to divulge any personal detail information about your own particular circumstance, as we are on a public platform as well as recording. So we want to try to protect your privacy as much as we possibly can. And we don't want any detailed information getting out there for everybody to have access to. Two, in addition to that, because it's a public platform, there's some things that Miss Jessie cannot answer for you guys because it is too specific, but she'll get into that as well. But I do want to give that disclaimer that the information that does get presented here is for educational purposes only. It is not to be considered legal advice. And you're probably going to hear that again throughout this presentation. So just know that we want to make sure that we reiterate that to folks that are coming in to listen to the information that we have. So do keep that in mind. If you are joining us on via social media, please feel free to type your question into the comment section. I am monitoring that as well, and I'll try to get those questions addressed as well, since you can't see the chat. And won't be able to kind of chime in or unmute yourself, but you do have the opportunity to do that as well. If you'd like to wait until the end of the presentation and unmute yourself or raise your hand, and we can call on you, and then you can ask your question aloud as well. But again, as general as you possibly can without, getting into the attorney-client privilege and too much personal detail. So do keep that in mind. With that being said, you all have the opportunity. We are here the first Thursday of the month for this presentation. To join us again next month, invite your family members, your friends, your relatives to all come back and hear the information. One thing I like to say is that we there's a lot of information that's out there. There's a lot of misinformation that's out there. We got a lot of people that are members of the street committee that are trying to tell everybody what they need to do. That's not relative to you. That's not relative to the state of Texas. Everybody's trying to tell you how they did it and whatnot. You are hearing it from the expert. You're hearing it from a licensed attorney in the state of Texas that is a practicing attorney in this field. So do know that as well. So don't get your information from somebody off TikTok that has an office in New York somewhere or whatever, trying to tell you what's relative to the state of Texas, because it's not. So just do keep that in mind as well. So again, a lot of information. I hope that you guys receive everything it is that you came here to receive today. And without further ado, we're going to go ahead and get started, because again, it is a lot. So, all right. Thank you very much for joining us again. Ms. Jessie, you go right ahead and get started.
All right. Good afternoon, everyone. Give me 1 second to get myself all situated with my slides, and we will get going. All right. All right, I think I'm ready. Okay, good afternoon, everyone. My name is Jessie Campbell. I am a directing attorney with Lone Star Legal Aid, and I'm here today to talk to you about legal advanced planning. So welcome. As Ms. Nia said, there is a lot of information that we're going to be covering today. Again, just go ahead and put your questions into the chat. I do watch for it, and sometimes I'm going to answer it as we go. But if you prefer to ask a question, please wait until the end, and we will answer those. And again, as a reminder for anyone watching us on a live stream via a social media or YouTube, you can put the comments in there. Someone will be monitoring that and get asked at the end or as we go. And so, because I have to once again do the same, which is to remind everyone that this is for educational purposes only. Please do not take what I say today as legal advice. Legal advice is very specific to your individual situation and what is going on and what you need. And so, but today I'm going to be talking about things pretty broadly, like, as it applies to anybody, but there will be, of course, exceptions depending on your situation. So be aware of that. And again, I have to repeat this when you are asking questions. This is a very public space. This is going to live on the internet. So please do not put anything in a comment or on this recording where you are asking something where people will be able to identify you and take your information and be well, unattended, bad actors that are out there. Okay. All right, so a little bit more about Lone Star Legal Aid. We are a legal aid organization. We are quite large. We are one of the largest legal aid programs in the nation and in the state. And so we serve 72 counties in the eastern and Gulf Coast region of Texas and 4 counties in southwest Arkansas. So we go from Galveston to Texarkana and from Beaumont to Waco is kind of where we are. We have 14 offices in addition to our Houston office, which is where I am located. We have 13 branch offices throughout those service areas. We do provide free legal services to financially eligible clients, which is based on the size of your household, the income and assets for that household. And we do a variety of civil legal matters, and the list is there: consumer, employment, family law, healthcare, housing, neighborhood problems, public education, and of course, estate planning, as I am here to talk about today. And I will let you know that, again, lots of information, and we'll talk about at the very end how you can apply for services if you believe you qualify in order for us to get an attorney to actually draft these documents for you. Okay. All right. So first off, we need to talk about the difference between advanced planning and probate. Sometimes people come here thinking we're going to be talking about probate, but really we're talking about advanced planning. So advanced planning and estate planning, different attorneys or different people will interchange those words, right? Some will say estate, some will say advanced, but for the most part, it's the same thing. We're talking about preparing and planning for death, incapacity, a care of minors or adults living with disabilities in our care for their care in the event of our incapacity or death. And then we'll talk very briefly about long-term care. So thinking about asset protection and becoming eligible for assistance in long-term care. So we will be talking about all four of those today. And then putting those decisions and what we want to do and those preferences into a legally binding written document. That's what advanced planning is, and that's what we're going to talk about today. But what is probate? Probate's the after part. So when you're looking at a coin, the before part is the advanced planning, before the need arises, before we're incapacitated, before we pass. Then probate is the after part. We have now become permanently incapacitated, requiring a guardianship, or we have passed and now our loved ones and beneficiaries are going to have to deal with the after part. So probate is the process. It's a court proceeding handling the estate after a person passes away. The word probate is a court proceeding, but sometimes people will just refer, not lawyers, we're very picky about our language, but some people will just refer to probate as anything that happens afterwards. There's probate alternatives. So instead of having to go to court, you may be able to do some type of document or something else that you can do instead. Or and that can be, some people will kind of put that all under the umbrella of probate, depending on who you're talking to. But that process is generally filing an application in court with an attorney. You are required to have an attorney to probate a will in the state of Texas. It's going to be, and then that person, the executor or the administrator, depending on the language, is going to be paying off the debt, conveying property ownership, and then managing any other remaining matters that need to be taken care of as a result of our own passing. So what happens in that court process is going to depend very much on what advanced planning documents exist and that were executed prior to our incapacity or death. So the probate courts are, they're in Harris County. We are a big enough county that we have specific courts, probate courts, and all these do is probate matters and guardianship matters. So when we have a need for guardianship. So that's the probate courts. There are some counties in the state of Texas that are a little bit less residents than in Harris County. And so they may be filing their documents in a county court at law. And so different names or different courts, but generally the same process. We will not be talking about probate today. So if you've come in today hoping to answer some questions because a loved one has passed and you have an executor or you don't have a will and you're not sure what to do, there's a cloudy title, and that's why you are here today. Unfortunately, I will not be discussing any of those topics today. I do invite you, though, to join us in my friend and colleague's presentation in a couple of weeks that talk about what happens in the after part on how to clear title to property. So kind of think of us as a joint effort there. And so Miss Nia will send you the calendar and you would be able to register for that event. All right, so first things first, it's an individual plan. Ms. Nia already touched on this, which is that I've never referred to it as a street committee. I am so going to take that now. But you don't want to just be asking random people or even friends and neighbors what they are doing with their estate planning because it's individual. Although, right, like every family has its own quirks, right? Different needs. We all have different things, right? And so even though that your neighbor may look very similar to you and your friend may look very similar to you in terms of the family and the type of property that is owned. The truth is that you might not actually know the full details and because they're not going to necessarily share every private detail of their family life with you. And so that will that they may have drafted with an attorney, you can't just grab that will, copy it, change out the names, and then it's good to go. So we have to look at what's going on in your specific situation and the types of things that impact your advanced planning, your family members and the dynamics. I wish we can say that all families are happy families, and but that's not always the case. There are estrangements, there are disownments, there is sometimes disabilities that we have to be kind of taking into account. And so you got to be looking at those situations, the type of property that it's owned. Do we have a house? Do we have land? Is it co-owned with somebody? Do we have any what type of financial accounts do we have? Is it just a bank account, or do we have investments and retirement accounts that we need to be taking into account? So it's like, do we have family heirlooms, any items of specific value? So those are the types of things that you would need to be thinking about, because those can have different impacts, and there's different rules on how we can pass some of this property on. Who is inheriting? Is it a minor that's potentially inheriting? Is it an adult living with a disability who's receiving public benefits? That's a factor. We need to be aware of that, because an inheritance can potentially disqualify that individual from receiving their public benefits due to their disability. So those are, so we need to think about who's getting it and making sure that we are bequesting, that's the legal word for giving who the heirs or how the heirs receive their property, like making sure that we're doing everything so that way we minimize any problems that they may have when they inherit the property. Our current health situation, we need to be looking at what's going on with us currently, because that can inform your advanced planning around your health, like potential incapacities and things along that lines, right? And then, so you're going to want to take a look at that. And of course, long-term health conditions and family history. We may be healthy and fine today, but we have a family history of incapacity. It's like, medical science is wonderful, and hopefully we're going to solve all of this before it becomes an issue for us. But there's also a possibility, hey, I have a family history of dementia. I need to be thinking about that. So, you might want to that can inform your advanced planning as well. So just kind of take that into account. So when to update? I am always joking that I am bad news Jessie. Lawyers are here to look around corners and to plan for problems, right, before they arise, and hopefully stop them from before they arise. So I am of the opinion that as soon as you know that 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 nothing is certain in life, you need your advanced planning. I always joke that I have friends who, when their children turn 18 years old, that they have got gift their child the gift of estate planning. And it's true. I actually do know a couple of people who have done that with their adult children. So you should do it whenever you realize that you need advanced planning. But otherwise, you need to kind of take a look at your documents when there's a major life change or a major property change. So marital status, obviously that would be marriage, divorce, and widowhood. We would want to take a look at our marital status at that point in time. But also, what people don't forget, and people sometimes forget, separations. If you are separated and and haven't gotten a divorce, you also are going to want to be sure that your advanced planning is taken care of, because guess who your next of kin is, according to the state of Texas? Your spouse that you no longer live with, right? So if you're separated, you want to do that. And I do see people who've been separated for years, just for various reasons were not able to get a divorce when they first separated. And now it's 5 years later and they're still legally married. And so we would want to be sure that you're also drafting documents with taking that into consideration. Children, and this would be new children, right? So you've adopted, or a child has joined your family. And hopefully no one ever experiences, but sometimes children do pass. And then, of course, as we age up, as our children turn into adults when they turn 18, that's going to impact what you decide to do with your advanced planning documents. Health changes. I already talked about this. You're in your individual plan, but of course, if your health changes and you're talking to the doctor, that may inform the kind of document planning you would have related to your health planning. And then major property changes. Now, I'm not talking about like, you've bought new furniture. you know, maybe you do need to update your will because of new furniture, but that's going to be considered personal property. What I'm talking about is going to be, did you sell or buy a house? Did you inherit a house? Right. So we're talking about that. Cars, family heirlooms, that are of value, right? Like those are the types of things that you're going to want to take into, and when I say a value, I don't necessarily mean just money, right? There's also sentimental value to family heirlooms, and you will not be surprised how many people will fight over those items. And so if you inherited a family heirloom, that I don't care how much it's worth. If it's valuable to your family, you may want to consider how you do your estate planning for that piece of property. Though more specifically, I'm usually talking about houses and cars. So if you buy a house or sell a house, you buy a car. Selling cars is not as much of an issue, but that where there's a piece of paper, a legal document that shows who owns the property, you're going to want to do something with your advanced planning for the new property or the loss of the property, right? So those are the things we're talking about. All right. Choosing your representative. In all of the documents, there is a person, right? There is a person that you are giving authority to act on your behalf. And so they're called different things depending on the document, right? There is the attorney in fact, there's the executor, agent, right? Like, so they all have different names, but they are all essentially serving in the same role. The person who's acting on your behalf when you are unable to do so because you are incapacitated or because you have passed, right? So they're standing into your shoes to make sure that your wishes and what you want is done. And so when you're thinking about who this should be, you should be selecting someone that you know and you trust and what will do what's in the best interest for you and your family, or as you would do it, has what you would make those decisions and plans. Of course, not of course, we do recommend that you select one person. It is possible in some of these documents to have co-folks, but I really advise against that as a general rule. I usually say, please pick a person. And the way I heard it once described to me, and I think is the one that's applicable, it's like, do you really want two people driving a car on a highway? You really don't, right? Where a person, I remember when I did my driver's ed, I was in one of those cars where my driver's ed teacher could just step on the brakes whenever they wanted, like they had a connection, right? That's jarring, right? Now it was needed. I was only 15. I needed some help. But you don't really would want that. The same can be true when it comes to your advanced planning documents. One of the reasons that you want to have advanced planning is to avoid family conflict, to make sure that your wishes are being done and people understand what's clear. And if you have two people who have the exact same level of authority to make decisions or to do what they need to do, and they don't get along, then you're going to have that family conflict happening. And then that doesn't solve the problem. And then what happens if you have a disagreement? It doesn't mean that they don't like each other or they hate each other and that life. They just disagree. They both might have loving decisions to make, right? Like, and so the example I use is making medical decisions. One person may be like, I want to go down this path of treatment, and then another person, if they're co-executors, want to go, not exactly co-agents, but the other person is like, no, I think we should do this type of thing. And that's a loving decision, right? That's not a, oh, you're not, but they're it's a disagreement. Then who's the final say, right? Like, who's the final person to have the ability to do that? Sometimes people end up going to court to fight over who should be the one make a decision. So we generally advise against shared authority, and because it avoids those questions, it avoids those problems. And other ways you can kind of make sure that people are involved in that is maybe they can serve as an alternate, or you can have them be the primary person on a different document. So be sure you're discussing the decision with the person. Don't let it be a surprise. Like, no one should be showing up and be like, wait, what do you mean I'm making medical decisions? I don't know how to make medical decisions. They never talk to me about it. So be sure that they know that they're the person that's been selected, and discuss what you would want. Like, explain things to them. It's like, this is how I think about medical decisions. This is how I think about property decisions. And I want to talk to you about this so that way when I am not able to tell you what I want, then you will already have all the information that you need to be able to make the decision on my behalf when I cannot do so. So you want to kind of be able to do that. One of the things that I don't have on this slide, but I think that is important to say, is be sure that you have conversations with the people who are not selected. there is kind of this idea that sometimes people have where they're like, I'm the person, I'm the person that's definitely going to be the one they're going to pick. And, and then they're surprised when they're not. So you want to have these kind of conversations with them and to explain why you didn't. And the reason why is because you're not going to be able to do that. And it doesn't matter how old you are, right? When someone you love and you feel trusted you, doesn't name you has that person to take care of them. You're like, what's wrong? Don't you trust me? Why don't you know? And when you are not able to explain that, then they create stories in their minds and they might not be something that will ever be resolved. So you want to have those conversations. And the reason why you want to do that is because the person who you've named is doing work. Like this is not like, right? This it's actually like, right? Think about how much it takes to manage your own life, right? Like it's like, oh, I gotta pay bills, I gotta make sure I get to the doctor, I gotta, take my medicine, right? Like all of that stuff. Someone's taking responsibility for that. For an executor on a will, they're taking the responsibility to find a realtor to sell the house, make repairs, write deeds, have a garage sale, right? Like that person is doing that. And then there's paperwork, including filing tax returns and things like so they're taking on all this responsibility. And then on the medical side, it's making medical decisions, making sure you get to the doctor, like maintaining the records in your mind. That's a lot of stuff, right? Like that's a lot of management and care that you have to do. And sometimes the person who would be the natural choice, the oldest child or the spouse, may not be the best choice, right? So you would want to have a conversation with those individuals and be like, look, honey, I love you. I trust you. And I know that you would be great at this. But remember, I won't be here. You will have experienced a loss and you will be grieving. And, and this is a lot of stuff. It takes a lot of stuff to do this. And I want to be sure that you can be there for my spouse, to be there for your grandchildren, and I want you to focus on the healing and the new reality that now exists. And let cousin Bob, who's an accountant, handle all the paperwork. He's happy to do it. He's offered to do it, and he's doing it as a loving decision. So that way we can take care of that. So just kind of keep that in mind as a way to kind of have these conversations. So some key takeaways. You're probably going to hear me talk about this a couple of times, but one of the key takeaways is you must do something. Although we are not going to be talking about probate today, one of the things that everyone needs to be aware of is that when a person passes away or become incapacitated, you need to do something. When there is a person who passes, you need to go talk to an attorney with all of the documents that you have in place and have an attorney evaluate what the next best steps are based on the documents that were drafted and what the estate has at that time. And so there is time. Time will be an issue. And I'll talk about some of that as we go. Everyone needs a will. No matter what you hear after this slide, what I say about avoiding probate, doing other things, everyone needs a will. It's better to have a will and not need it than to need a will and not have it, because we'll talk about that. Access to the bank account. You want to be sure that your beneficiary or the person who's going to be handling your final affairs has access to a bank account. If a probate is required, the average length of time to do probate is around 4 months. And so whoever it is needs to be able to pay bills and things until that happens. But also, are a lot of people that might be the only asset that needs to go through the probate process. And there's things that you can do to minimize the need to go to probate. Again, I'll talk more about this as we get to each of these items. And then the last one is, at minimum, everyone needs a statutory durable power of attorney and a medical power of attorney. All right, so understanding property and transfer of ownership at death. There is a lot of misconceptions around this that prevents people from doing the best type of estate planning that they can for their homes. The first one I get is, I don't have anything. I don't need a will because I don't have anything. Everyone owns personal property. And as I already mentioned, sometimes people will fight over that personal property because it's sentimental. It's things that makes you think of grandpa. And every time you went to go see grandpa, he has his favorite mug. And so you want his favorite mug. So there is things along that lines. But even ignoring the sentiment, there's a practical part to it. If you don't own personal property, chances are that means you live somewhere that you don't own, right? Like you're renting or living with a family member, right? Like you're not the primary homeowner or you're not the homeowner. Well, who's going to deal with that, right? Like, is it going to be an estate sale? Is the proceeds going to be divided among the children? Who's going to be responsible for that? Who's allowed to be able to come in and take the property and deal with it, right? And so we have our clothing, our furniture, and jewelry, cars. Cars are personal property. So everyone's got something, and so it's better to have something in place. Someone must have the authority to distribute the property, right? So I already talked about that, right? So it's kind of like, yeah, you can't just let any random person walk in and be able to take the property and have a garage sale, right? Like who's allowed to do that? And they will also need instructions on what to do with that. Once the property is sold or dispersed, like what do you want us to do? Do you want us to just take it all to a charity or, so like those are the things that are like, well, we don't know. Titled property, those are cars and houses and land, RVs, mobile homes. So title property, they have a piece of paper, a legal document that shows who owns the property, must go through some type of a legal process to transfer title of that property. I talked about before, if someone passes away and there's no will, nothing is done. The person the property will pass according to the laws of Texas. And then now the heirs who may live in the property or want to sell, there's actually not a piece of paper that says they own it. And so what you now have is a cloudy title. And a cloudy title can make it very difficult to sell the property. It can diminish the value of the property. So even if someone is willing to buy it without title being cleared, they can, it would reduce the value significantly because of the legal work that will now need to be done to clear the title for the person or the company that's purchased the land. So it can create a lot of problems. And so, which is that other session I mentioned in a couple of weeks with my friend, that's what she's going to talk about, right? It can create a lot of problems for people. And so you need to be sure that you do something to ensure your title property passes. Verbal agreements are not enforceable in the state of Texas when it comes to wills and property and things along that line. So saying things like, we got an agreement. Susie, my wife, is going to definitely do what we talked about. Great. I'm glad you have an agreement. Put it in writing, because otherwise there's no indication what's going to happen with that property, right? Susie, once she's a widow, maybe like, I know I agreed to give this house to your children, but I'm going to go ahead and give it to my great niece who's wonderful, right? Like, so put it in writing, if you got some stuff, right? So make sure if you have some plans, put it into writing because, things happen that way. The last thing of misinformation is that some people believe that when you own property together with somebody, it automatically goes to the person who co-owns it with you. That is untrue. So the default in the state of Texas, when more than one person owns the same property, is that they own what is called an undivided share in the property, which means that they own a portion of it. So if there's two people, you own 50% of the property, even though and the other person owns 50% of the property. And, so when one of the two passes, the property passes according to that person, that's 50% is going to transfer according to that individual's will, or if there's no will, intestacy laws, right? So that's what's going to happen with that 50% of this half. The other half still belongs to the other person who owns the property. That doesn't mean that the heirs is the same person. And so in some instances, it may be, right? If you don't have a will, like, you want your spouse is the one who's going to inherit the property without a will. Maybe that's the case, but there's other reasons that you need a will, which is to make the probate process easier, which I'm going to talk about in a couple of slides. But it's, so it's a misconception that just because you own it together. A lot of people think that that's what happens in community property. Oh, community property, my spouse automatically gets it. That's untrue. And so, so you need to be sure that if, that you're writing wills and or doing other documents to to ensure that, to make sure, did you want your spouse to be able to inherit it, or did you want your children to inherit it? There's like different things, right? So keep that in mind. So now we're going to get to a will. So last will and testament. A will is a legal document in which a person, called a testator, just legal language, writes down what they want to happen to their property and debt, collectively known as the estate, after their death, and who they want to manage that estate. That person is called the executor. And that's basically what it is. I'm going to check something real quick. All right. And so why is this important? I said everyone needs a will. What happens in the probate process is very much contingent on what type of legal documents exist. And so when people are like, oh, well, the law automatically is going to transfer my property the way I want it to. Oh, let's pump the brakes a little bit on that, because it's still going to be difficult. So when you're talking about needing a will, as it relates to the probate, a well-drafted, properly executed will makes the probate process in Texas very easy if you need a probate for the estate. So this is also really important to hear, and I'll probably repeat it in another slide, in about 3 slides, which is that estate planning, probate laws are state laws. They're not federal laws. So if you are seeing federal or experts from other states talking about this is what you absolutely have to do to avoid probate, because probate's terrible, it's expensive and long, and it'll take you 5 years to do it. So that you need to do X thing to prevent that. You need to do Y thing to make it easier. That may not be true, because it's a state specific process. And in Texas, a well drafted, properly executed will makes the probate process really pretty simple. It's going to be one hearing. You're going to go to court once and to admit the will and get named the executor. They're going to give you letters of testamentary to be able to do the work. Then you're going to do the work. You're going to sell the property. You're going to have the garage sale. You're going to do whatever it is that the will instructs you to do. Then there's going to be a couple of documents that need to be filed with the court, but it's not going to court. It's just filing some documents that you have worked with the attorney to provide that. And then that's it. Then you close the estate. The work still has to happen regardless, right? And so that's what makes a properly executed will, well-drafted properly executed will, makes the probate process easier. Without a will, what ends up happening is that you will end up in a situation where now you may have what is known as a dependent administration, as opposed to an independent one, where now the judge has to make decisions, has to approve everything. Yes, you can sell the house at that price. No, we cannot accept that. Nope, now we got to negotiate with the creditors, and this is how much you got to pay each creditor. And then you got to job it. That's what makes it lengthy and difficult, and can cause a lot of problems for the person managing the affairs. And so don't let the idea of having to do a probate, because sometimes you need a probate. I am going to talk about how to avoid probate in a minute, but sometimes you need a probate, and you should not be scared of having to go through a probate process if it's needed, because sometimes it is the best way to go forward. Okay. All right. Neo was saying, don't follow TikToks. Oh, it's the bane of my existence. I see so many TikToks with bad legal advice for the state of Texas, but maybe right for Nebraska. I don't know. I don't know where they are. They don't tell you where they are usually and like what law applies. They're just being like, you must do it this way. So be wary of that. Be wary of the internet. Just because it's on doesn't mean it's true. So including myself if you're watching me on the internet, but I promise I'm telling you accurate things. Non-probate assets. So these are assets that are owned in such a way that the ownership transfers to a specific person without having to go through the probate process. This is just the law. It's just the folks in Austin were like, hey, we're going to make these laws. It's also some of it's federal law, right? That you don't have to go through the probate process. If you already have these documents in place here, when a person passes away, we would need to submit the death certificate to the financial or whatever the institution is, and then that's it, right? Then the property will get transferred. And so for most people, non-probate assets are financial in nature, retirement accounts, 401ks, IRAs. Those are going to be the types of accounts that would be that you're going to go to your financial institution. That's going to be the things you have, like a Mutual America, Schwab, or things like that, right? You're going to name a beneficiary. Life insurance proceeds, same thing. You're going to name a beneficiary, and then payable on death accounts are the other thing. Sorry, I'm getting pinged with things. So what is a payable on death account? These are bank accounts, credit union accounts, checking, savings account. So this is where, remember I talked about like making sure you got something to do with your bank account. For many people, for many households, the primary assets that they have is a house, a car, personal property, and a bank account. Those are the primary things. I'm going to talk about how you can handle your house and your car, avoiding the probate process. Personal property, when that's the only thing in effect, usually you don't need to probate a will for personal property. And then there is your bank account. Bank accounts without a beneficiary, without co-ownership, must go through the probate process. There is typically, for most of these banks and credit unions, not a way to avoid the probate process. The only way you can avoid that is to name your bank account or savings account, checking or savings account, has a payable on death account. That's naming a beneficiary. There is another option, which you're going to see, the joint tenancy with right of survivorship or co-owners. You can make that person who's going to be inheriting the property the co-owner of your property, right? Of your checking account. Then they can sign, they can write checks and things like that. I usually always say there's no right or wrong there. Obviously, if you trust the person to not do anything bad, then do whatever makes sense for you and your family. Right. And so, for example, I use my family a lot for reference, right? I am on my mom's checking account. I am her power of attorney as well, right? And so I'm on my mom's checking account because I handle her financial affairs. And so, but I only pay her bills, right? Like I'm not going in and being like, Mama's going to buy me a bad new bag, right? So it's like, right. So that is a way to do it. And so in the event of my mom's passing in 100 years, I will have access to the account and I'll be able to disperse the funds in the account according to the terms of her will without having to go through a probate process because I'm a co-owner. So if that works for you and that's and that makes sense in your family situation, then you can do that, right? But otherwise, some people don't want to do that. They're like, no, there's no reason for them to have access to my bank account. I just want them to be able to inherit it. Then you're going to change that into a payable on death account. And you just do that at your financial institution. You just go to Bank of America, Schwab, wherever it is, right? TD ECU, whatever, right? And then you're going to do it that way. The last type of a non-probate asset is the exception. When I talk about co-owners, right? Typically, as I said, the co-owners of property, it's going to be your percentage, your 50%, your 30%, whatever it is that you own, is going to pass according to your will. Your co-owners don't necessarily get that unless you name them as your heirs, right? A joint tenancy with a right of survivorship is a way that you can set it up where co-owners, where when on the passing of one, the other person or persons automatically inherit that property. So typically, under normal circumstances, you own your property with another person. Your 50% is going to go to your children if you say that's what you want, or whoever you name, right? Under a joint tenancy or right of survivorship, your half goes to the other co-owner. That's how it's going to work. And so I always say that's not the default, by the way. That doesn't happen in Texas. You have to convert your property. You have to make your property a joint tenancy with a right of survivorship. There's an action you must do. I always recommend you talk to somebody about that before you do that, right? There can be a lot of unintended consequences, right? Just in the same way, you're like, I really wanted to go to my spouse, right? They're going to be able to do whatever they want with it. And it's not, if you have a joint tenancy with a right of survivorship, they now own the property. And if you have children from a previous marriage and you're like, okay, yeah, they're going to own it, but I want my kids to be able to get, to be able to sell the property on her passing, that you don't want to do a joint tenancy with a right of survivorship in that situation. You want to do something else. So, I always say be cautious. Do it if it makes sense in your family, but be cautionary about it. And you may want to talk to an attorney, an advisor, to make sure that it is really the right path forward. It's very difficult to undo, change your mind, because once you make it into a joint tenancy of right of survivorship, everyone has to agree to convert it back to the standard way, the co-tenants situation. So when you're doing your advanced planning, this is not a document that we prepare. This is not something lawyers prepare for you, right? Be sure you're checking that, making sure that your financial accounts have beneficiaries listed, making sure that that, you know, if you're divorced, that your spouse is not the person who's going to be inheriting the property, right? So just be sure that you're your ex-spouse. So you want to check these accounts to be sure that the beneficiary is listed, because they will not go into the probate process. Only time they will is when there's no beneficiary listed, and then now it becomes an estate property, and it will get passed, and it will be handled according to the terms of the will and probate. Oops. All right. Now we're going to talk about, I just talked about your bank accounts, how to avoid the probate process with the bank accounts. Now we're going to talk about how you can avoid the probate process with your house and your cars. That you can accomplish through what is or our transfer on death documents. So there are two types depending on what the property is. For real property, that's a transfer on death deed. So this is a deed that you would be executing. For vehicles, now that includes your cars, mobile homes, and RVs. That's going to be a beneficiary designation of a motor vehicle. Upon the person's passing, the property automatically transfers title to the person named in these documents. No probate process is needed. Now, the person who's doing the transferring, you, right? You still own it. You can still sell it. You can still mortgage it. You can still do whatever you want with it. It's still yours. They don't own anything. They can't do anything with it because they don't actually get it until passing. And that's when they actually own the property. So they can't like go over and be like, you know, hey, I'm going to inherit this house. Can I go ahead and get a home equity loan on it? And they're like, well, you didn't inherit it. It's still owned by Bob. You can't take that. So, but this is a great way for many people to be able to transfer their property without that. So let's talk about when you would use this, right? This is, you know, I usually recommend that you don't want to use a transfer on death document when there's instructions, right? So the transfer beware, not ideal in all situations, is what I'm talking about right now. Like if you want to create instructions, that needs to go into a will, because otherwise it's not going to be enforceable, right? Because it's a deed. You're drafting a deed for your house. You're creating a title, a car title for the motor vehicle. And so if there's going to be instructions, you probably need to put that into a will if you want it to be enforceable. And so for some examples of instructions that might happen, I want my spouse, who is a second marriage, right? I want my spouse to be able to live in the property completely on their own, you know, without worrying about that. But upon their passing, I want my children to inherit the property equally. That's an instruction. Can't do that in a transfer on death deed. Another instruction would be, I want the house to be sold, and, you know, but Susie was wonderful. Gave me the $10,000, $20,000 I needed to replace the roof on the house. And after, you know, Hurricane Ike, whatever, right? And I want Susie to get that first $20,000 after we pay out, after the house is sold, and then the remaining amount to be divided equally among the children. That's an instruction. You want that to go into a will. You can't put that into a transfer on death deed. That's not, you know, it's like, you know, so those are going to kind of be the types of instructions that you would have. You're going to want to put that into a will before you put that in a transfer on death document. Some other things that you may want to take into consideration is on your vehicle. For a lot of people, it's kind of pricey. Like it can be anywhere from $60 to like $120, depending on the cost of things in your county. You know, you would be filing these documents in the county where you reside, and where the property is located. And so some people, I may or may not recommend that you do it for your vehicle. I just bought a new car a couple of years ago. I don't anticipate we're going to own this car until it's dead, right? Like we're going to drive it for 10, 15 years, but I don't expect it to be my last car. Like I anticipate that I'll probably buy another car in my lifetime, right? So I probably would not do a transfer on a motor vehicle designation for my car, but you know, my mom's car is probably the last car that she's ever going to own, right? Like she drives like one day a week, right? So I might want to recommend it for my mom to be able to do that. You know, the other things to consider though, you definitely want to do it if you have a motorhome, an RV, or a mobile home, right? Those two are usually the things I do recommend you do beneficiary designations for, because you typically own those for a long time. And so mobile homes are obviously your house, like it's where you live. And there are people who reside in their RVs and they are traveling the country, living the dream, but their RV is essentially their home and they're going to own it for a while. Those things I do recommend that if you anticipate you're going to have it for a while and that's your home, then you should probably consider doing a motor vehicle designation at that time. Now, that being said, for motor vehicles, it's actually not as, for mobile homes, it's a little different, but usually for a car, if there isn't one there, the process is actually pretty simple to transfer it, even without having to go through the probate process. If the only thing you need to worry about is transferring title to your car. So when you're like, oh, Jesse, you just said the bad things can happen at any time, not that long ago, right? Like, just because you think you're going to live to be 175 doesn't mean you will. And so it's like, what happens then? There is still an easy process. Thankfully that process is pretty straightforward. So, to kind of ease your mind on that. And so those are kind of things to think about. Other thing to also consider, these documents take priority over a will. And so be careful of that. So if you write a transfer on death deed giving the house to Susie, and then you change your mind, and so in a will, you write a will giving the house to Barbara, well, Susie's still going to get the house. The will doesn't matter because the transfer on death deed gives it to Susie. Same thing. You write a will giving it to Barbara and then you execute a transfer on death deed to Susie. Susie gets the house. So they automatically, because they don't become part of the probate process, right? The ownership automatically transfers upon the passing of the person. And so it doesn't become part of the probate estate, which is why the will never govern it. And so kind of keep that in mind when you're doing that, right? So so if you change your mind and if you've done a transfer on death deed, you need to revoke it. Like, you can't just write a will. You have to revoke the transfer on death deed, so that way it's no longer effective. So I did just get a question about what happens if a couple executes a TOD and then one of the spouses passes. Does the surviving spouse need to redo it? Maybe. It depends. There actually is a way to transfer to write a transfer on death deed in such a way where the next generation of heirs is named after a surviving spouse passes. And there's also a way to not do that. So it depends on how that original TOD is written, whether or not if it's written in such a way that the spouse has it basically for life and then it passes to children or whoever the next beneficiary is, or is it written in such a way that the spouse doesn't inherit it, in that they wanted to have to do something different. So it's a non-answer. Maybe depends on what you write, right? And that a new transfer on death deed may be needed depending on the original transfer on death deed. But if it's done in that first way, which is that it goes to your spouse and then to your children and you both sign it, then you may not need one. But so that's kind of a non-answer, but it's what lawyers do, right? Maybe. So but there is a possibility you can do it without having to go through a second round of transfer on death deeds. Okay, all right. Bad news for everybody. Debt survives. There's some misconceptions around what happens with debt after a person passes away, and it's because of things that do happen, right? I hear things like, well, you automatically don't have death, right? Like it's like the debt gets paid off automatically. Well, that's not quite true. So the estate is still responsible for paying the debt, and in the event of a person's passing, right? And so what will depend is how much the debt is and how much assets are available to pay that debt. And so sometimes if you're insolvent, if the estate's insolvent, then then the debts do get discharged, but not always, right? And I'm talking about credit card debts, unsecured debt, credit card debts, remaining medical bills, those types of things. So it really just kind of, so it just kind of depends on what's going on with the asset of the estate and the type of debt that they have when it's unsecured. Now, secured debt, you must figure out a way to get this stuff paid for. Not you. Someone's got to figure out how to get it paid for, because you cannot have a secured debt. And so these are houses with mortgages and cars with car loans, because we know what happens when we don't pay those. We get it foreclosed or the car gets repossessed, right? So that property will be taken back if it's not paid for. So the heir, so even though technically the estate is responsible for paying off any of the debts, if the estate doesn't have the resources to pay off the mortgage, the beneficiary, the heir, is going to be inheriting that property subject to that debt. So if it's a mortgage, most mortgage companies will work with the estate during the probate to allow time for the deed to get transferred over and for the person to get financing in their own name to pay the debt, which is why I talked about how important it is for someone to have access to the bank accounts, because someone's got to pay the mortgage, right? And so if there's funds in the bank account for the estate, then the estate can continue to pay the mortgage while the probate is in process and be able to do that. Now, if it's subject to a transfer on death deed, what happens there is that someone's still got to pay that mortgage, but someone's going to have to figure out, like, you're going to have to work with the financial institution that holds the mortgage to kind of figure out, hey, can I assume this loan? Can I just take on the loan and pass it and pay it? Or am I required to do refinancing, or can I just pay it off in some way, right? And so so something has to happen with the mortgage. This is traditional mortgages I'm talking about right here, where there's some wiggle room, there's some time to get it situated. Reverse mortgages, however, do not. There is a clock on that. Reverse mortgages are due 6 months from the date of death. So not the date of the probate starting, not the day after funeral, date of death, 6 months. I alluded to it earlier. I said it earlier. The average amount of time to start a probate process is 4 months. So that means some people started sooner, some people started later. A reverse mortgage is due 6 months, again, 6 months. So someone needs to work very, very quickly. If they're going to sell the property and it's part of the probate, you got to get that probate started, right? So that way the executor is in place so they can sell the property, pay off the reverse mortgage. If someone wants to live in that property, they got 6 months to get financing, right? To get financing to pay it off, either through the mortgage or transfer on death deed, right? So they're going to have 6 months to be able to do that. There's things that you can do from your planning. If you have a life insurance policy that will cover the mortgage and you want to do that, then make sure the life insurance policy goes towards that, right? If you're going to do a transfer on death deed, name the beneficiary of the house with the life insurance policy and let them know, you're going to have a life insurance policy that will pay off the mortgage. It'll pay off the reverse mortgage. And so you're going to get it. Now, if you want something different, like say that your life insurance policy is more than what the mortgage is, and you want the remainder of that to pass according to be shared among the other heirs or something like that, that's a will. Remember, instructions, you need to go in the will. And what you would do in that kind of a situation would be to put the estate as the beneficiary of the insurance policy, and then the executor will be responsible for paying off the mortgage according to the instructions in the will. So things like that. Don't do this automatically without talking to an attorney. But it's like, because again, like you need to know other things to be sure that your will is properly drafted. But there's ways that you can kind of plan for that debt if you want your estate to be paying for it. But otherwise, let the beneficiaries know there's a mortgage, either a regular mortgage, a traditional mortgage, or a reverse mortgage on the property. So that way they're aware of what they need to do. If they're planning on selling the house, well, give them the maximum amount of time, right, to be able to do that. And so just kind of consider that. I think I just answered that question about the debt. But there's ways you can manage it. If you know that they're going to pay, I am not a fan. I didn't talk about this in the transfer on death documents. I'm not a big fan of having multiple people inherit the property under a transfer on death deed. I think that it can create some problems, especially if there's kind of like expectations, right? If you want all 3 of your children to inherit the house and then you're expecting that they're going to sell it, and you want to do it under a transfer down death deed as opposed to going through the probate process, there's so many conflicts that can happen and something like that. Who's going to be responsible for deciding what the offer price they're going to accept? Who's going to decide if they're going to make repairs beforehand, right? There's so many conflicts that can kind of happen in that I, as a general rule, would kind of prefer that it's done through a probate process, because you don't know what kind of conflict will arise in that. And so, but like, if you really know that your children and whoever is going to be inheriting the property, that you really trust them, that they're going to actually do what you say, what you instruct them to do, then you can do a transfer on death deed to, you know, to either one person with the instructions sell it and then pay the mortgage first and do that, or, you know, all three inherit it. But there's a lot of reasons, which is why I talk about that individual plan. Like, go back to that individual plan, that very first slide, like, and think about that. You may want to talk to an attorney about really the best way to coordinate your will, transfer on death documents, and how to handle the debt that exists, that will potentially exist at the time of passing. It's possible you might not be any debt. If you're 30 years old and you just bought a house and you do a transfer on death deed, well, you might not pass until you're 175, right? And that mortgage will likely be paid for by then. So, you know, like, you're going to have to look at all those kind of factors together. Okay. All right, now we're going to switch over to the other planning documents. That's the bulk, the big stuff, the one that's really complicated. That's it, the will transfer on death deeds. Planning for death is the most complicated part of everything else. Everything else we talk about here gets a lot easier, but same things still apply. Individual needs, individual plans, who's going to be responsible, and what do you need? So, statutory durable power of attorney. So what is this? This is a document that names an attorney in fact, an agent, person, who will be acting on your behalf to make legal and financial decisions only, legal and financial decisions. And so there's a choice of when it's going to be effective. You can make it effective immediately, which is actually a default. Be aware of that. Like, if you get the template and you don't look at this, the default is immediately. Or springing. This means that it only is effective at the time of your incapacity, and that requires a doctor's examination and a determination by a doctor that you are now incapacitated, and now the statutory durable power of attorney is effective. So let's break down what it's called. Statutory is a statute. The folks in Austin wrote it. You don't even have to think about it. They've already written the document. It's a template. You just go in and you make your decisions, and then that's it. So that's what makes it statutory, is that it's a statute, it's a document in a statute. Durable, it survives your incapacity. So, right, it retains its effectiveness. There's no expiration date on it, like, unless and until you, who drafted it, make an expiration date for it, like you revoke it or you regain your capacity if it's springing one. So that's where statutory durable power of attorney is what it says. Remember what I said. There are 4 things you need to remember. Everyone needs a will. Covered a lot about that. You need a statutory durable power of attorney. It's not intended, just letting you know, it's not intended to be a permanent document, but it can be for, you know, if incapacity lasts for a while, then it can become a permanent document until somebody says, no, I really need a guardianship to be in effect. I want to talk a little bit about, like, how to choose between immediate versus springing. It doesn't really matter. It's what you want, what makes sense for you and your family, individual plan, remember? Losing my family again as an example, I have a power of attorney for my mom that's effective immediately because, as I said, I already handle her financial matters. I already pay her bills and things like that on her behalf for her. And so for her, it made sense to make it for me to have an effective immediately power of attorney for her. You know, she trusts me that I'm not going to do anything I'm not supposed to do with those powers. I'm not selling our house, you know, without her knowledge, right? And things like that. I'm just trying to help my mom live her retirement years without a lot of stress about having to write checks and things like that, right? And she wants me to help do that for her. And so, but, you know, it can be springing. And springing is like, you know what, though? I'm fine. I want to do everything on my own. I don't want this effective until I no longer am able to do that. That's fine too. Like, so really whatever makes sense for your family and for you is what you should do. There's no right or wrong. The only asterisk, the only thing to think about is that the reason why you want it to be springing, only effective once you're incapacitated, is because there's a little part of you that's a little worried that they might take the power and start doing something with it. That is actually not an effective timeline you're worried about. That's, have you chosen the right person? Because if you don't trust that person to be, you know, truthful and right-minded when they have the power immediately, what are you going to do when they have the power and you are not able to do anything about it? You're incapacitated. You can't change your mind now. They have the power. And so if that's a concern, you need to think of a different person to pick, because that to me is a yellow flag that that's not the right individual selected to have that power, right? Medical power of attorney. This is pretty much after this, we start having two different documents, right? So the first part is that it's the the legal and financial side of things, and then we have the medical side of things. So the medical power of attorney is a document that names a person to make medical decisions when a person is unable to do so. It is only effective when you're incapacitated, because at that point in time, the you can't make decisions. As long as you have capacity to make your own decisions, your own medical decision, you get to make your own medical decisions, clearly. Like, the power of attorney can't walk in and be like, you're like, no, I really don't want to have that vaccine, or I really don't want to have that, procedure done. I don't want a blood transfusion. Your power of attorney can't come in and be like, give her that blood transfusion, right? Like they can't, because you have the capacity to make that decision. And so so just be aware of that. But you also want this. So those are our four things, right? It's remember, something's got to be done. Everyone needs a will, statutory durable power of attorney, medical power of attorney. Just like the statutory durable power of attorney, a medical power of attorney is intended to be temporary, but it can become permanent, unless and until someone says they need a guardianship to be put into place. And so that gives you the minimum protections. The will, the two power of attorneys gives you the minimum protection that you need. And I'm like, if you take nothing else from this conversation, please at least do those three documents, and then tell somebody they have to do something upon incapacity and death. Okay. All right. That leaves the remaining documents. I forgot, but this is the PowerPoint that I pulled up. So we're going to spend some time on this one. So these are all the remaining documents. And so that you should be considering about when you're planning your documents. They're not required, they're not mandatory, they're good to have. That's basically right. Advanced planning is you're trying to avoid problems before they arise. You're trying to make it easier for your loved ones when you are no longer available, either due to incapacity or death, to support them, to do this for them, to help them through this process. And so these are documents you should consider if they make sense for you, right? Disposition of remains is funeral arrangements. Who are you going to name to be responsible for handling your funeral? And I will tell you, there is so much conflict in funeral planning that, and I'm not saying that everyone does this, but there are some people out there that are a little bit predatory in their funeral planning, or services. And so people will fight. People will fight about, oh, this is how the funeral needs to be. Oh no, she needs to be buried in this cemetery versus that cemetery. Nope, she definitely needs to be cremated and versus being buried, right? Like so there can be a lot of conflict in that. So a disposition of remains is the document that names the person who's going to be responsible for that. And it's also a document where you can put in the instructions, right? So it's like, I want to be cremated and have my ashes spread. I already have pre-arrangements with Bob's funeral home and everything is already there. So you need to go and take care of it over there. So it's both. It's who's going to be responsible, and you can put in the instructions of what you want to happen at your funeral arrangements, and then put that into that document. Very useful to avoid potential conflicts. Sorry, talk a lot, you have to drink. And so the remaining documents are planning for incapacity. Supported decision-making document is an in-between. It's an in-between document. Very, very useful for people who have diminished capacity, but they're not incapacitated. So, right, what's the difference between that, right? Diminished is they need some help, right? It's basically, I can do some things by myself and not worry about it, but I need some help making decisions on this area, right? And so for example, if we're talking about aging up children and they have a disability where they're unable to understand financial concepts, right? And so they can work, they can live, they can feed themselves, take care of themselves, but they don't understand, but they're not going to be able to understand financial matters, like what does a mortgage mean and what does rent mean. I don't understand what the lease says, right? This is just kind of an example. There is usually a condition, right? Like there's usually some kind of disability that it's not just like, I'm 20 and I've never read one of these before, but I can understand the words I'm reading. Like there is some kind of a cognitive, diminished cognitive ability to understand it. Um, that's an example. You can have supported decision-making document where the supporter comes in and is like, I'm here to help you understand what you are doing. So, and support that decision making. It's also very useful for people who are elderly and who are getting diminished capacity, or there's a cognitive decline. Unfortunately, it does happen to some of us that as we age, our ability to understand concepts does shorten down. There's a reason why so many scams and are targeted towards elderly individuals, because the ability to identify a scam is very, very difficult. And when it's happening to them, like even sometimes they can see it happening to somebody else, but when it's happening to them, it's really hard to do that. People who are bad actors and these criminals who are doing these things are very, very good at it, right? And so, and sometimes I've seen things in my work, right, where I see letters and things. I'm like, that's good. Like that's like I don't like it's like one word that shows that it's not a scam, right? And so it's so if you are a person who's aging and you feel like you're noticing that about yourself, or like people have to kind of explain things to you a little bit more, you may want to consider doing a supported decision making document to kind of serve in that in between. Or if there is a dementia prognosis, then while you still have that partial capacity, right, that you can kind of make sure that you're getting supported. And so very useful document for a lot of people and something to consider depending on your situation. Declaration of a guardian in the event of later incapacity. So remember what I said, the power of attorney is the statutory durable power of attorney, medical power of attorney will get you there, but they're not intended to be permanent. And sometimes you may run into the person is incapacitated, and they might run into a situation where a doctor or a hospital will be like, no, we are now at the stage where that power of attorney is not sufficient. I need you to go to court and get a guardianship put into place. It could also be a financial institution that says that it's like, you know what? Like you've been doing a lot of stuff. You're making gifts. You're doing you need to have a guardianship in place before I let you do any further transactions out of this account, right? Like, and so it could be a school that requires it. Like, right, there's so many things that can happen where guardianship is needed. Generally, my recommendation is that once a person is considered permanently incapacitated, that a guardianship should be sought for. Because why? Why do you want that guardianship in place? There's oversight. There's a process. That means that there's a court order. There's a court that's going to be once a year. Someone has to report to the court that everyone's still doing what they need to do. But if there's a bad actor, now there's a way that you can get in and deal with that. You can sue. You can be like, hey, I think that this person is misbehaving and they're not doing what they're supposed to do. So there's this ability to kind of do something a lot quicker than when you only have a power of attorney, because now you have to go into court and potentially get a guardianship put into place, and and that can take time. That can be difficult and things along that lines, right? So declaration of a guardian in the event of later incapacity is something I recommend. It's a super simple document. Just like the power of attorneys, you would name one for guardian of the person. That's medical decisions, the care, where you live, that type of stuff. And then the guardian of the estate, that's the medical, that's the financial and legal decisions for the estate. They can't be the same person, or they can be different people. Depends, whatever you want, right? But if you are going to have two different people, one for estate, one for person, be sure that you know that they're going to get together and they're going to be, because sometimes a medical and care decision has a financial component to it, right? So if someone's like, nah, I want grandma to go live in this nursing home. It's great. This is what's wonderful about it. But then the person who's got the purse strings, right, is controlling the estate. It's like, no, I don't want to spend that much money for that, right? So then you have a conflict, and how do you handle that, right? So, so if you want to have two different people, which is possible, you can do it. Be sure that you know that they're going to get on the same page pretty easily. If not, then you might want to consider having one person for both. And so the other thing when it comes to a declaration of a guardian in the event of later incapacity, this also includes the people in your care. So if you are the guardian of a disabled adult or ward, then you can name your choice for the person to serve in that role after you, your successor. Same thing with minor children. Like you can name the person that you would want. You can do that in a will, and you can do that in a declaration of a guardian in the event of later incapacity. And you would probably want to, potentially you might want to do it in both, right? So, but depending on the situation. So that is something that you can put into there. Word of concern or issue to be aware of. Declaration of a guardian in the event of later incapacity is not a mandatory document, which means that the court is not required to appoint the person that you name. The person still has to qualify. There are legal threshold things that they have to meet in order to become qualified. And if the person doesn't qualify in that position, the court that is not required to name them, right? And so there's a lot of factors that impact the qualifications of a guardian. Financial reliability, right? History of domestic violence in the family with the proposed ward, and felony convictions. So there's some different things that can potentially make that person not be able to serve in that role. And then in which case the court will look at the alternate in that document. So the court will look at it. The court will like, okay, this is my first choice. Can this person serve? If they can, they're appointed. If for whatever reasons they can't, or they decline, the court was going to look at the alternate. And then if the alternate is not able to serve for whatever reason, then the court's going to look at next of kin. What's really good about these documents is that you can also name who you do not want to serve in that role. And unlike the other two, where the court can be like, nope, they don't qualify, I can't appoint them. If you say, I never want Susie to ever be my guardian because I haven't talked to my sister in 20 years and she doesn't know anything about me, right? That you say Susie can never serve. Sorry to any Susies out there. And and the court will be like, okay, so even though Susie has sister is next of kin, she's not going to serve. We're not going to look at the next person, right? So just kind of be aware of that. And for some people, that is just as or more important than naming the person that would be serving as the guardian. And so be aware that that option does exist. HIPAA releases. So HIPAA is our health information is protected. So that's the purpose of HIPAA, is that our health information is private, and those who are subject to HIPAA, which includes doctors, hospitals, their staff, it includes lawyers, so people who in the course of their business or treatment with the person obtains private medical information. We are not allowed to share that information with anybody without a HIPAA release. So that is basically what it is. HIPAA does not apply to your neighbor, to your sister. So if you told all of your health information to your neighbor, and your neighbor decides to go down the street and have a cup of tea and share that, they're not subject to HIPAA. It's only certain entities, typically medical, but it also includes other professions that get this information, that we cannot share that. And so what HIPAA does is you want to do a HIPAA release for, at minimum, the person you name as your medical power of attorney, and the person you name as the declaration of a guardian in the event of incapacity for the care of this person of the person. So that way they can obtain the medical information from your medical providers without running into any problems. You can name other people. So if your medical power of attorney is your oldest child, but you want all 3 of your children to be able to sit in and get that information, you can add those other children. So it's pretty flexible in that case. Why do you need a HIPAA release? Because it's a general release. So if you go to your doctor and you file a HIPAA release, every time I go to my doctor, I confirm that yes, you can tell the information to my husband, right? And to my mom. Those are my 2 HIPAA release people. And it's like, that's only for that doctor, that office. Like my husband cannot take that HIPAA release and go to a hospital and be like, hey, I need you to release it. She signed this. And they're like, well, no, that's only for her doctor, her primary care doctor, that you have that, right? So what you want, and the reason why you need this general release is to allow people to, the ones who are going to be making medical decisions, to go to any provider and be like, here you go. I need this information to be able to make my medical decisions on behalf of the person, right? Yes. And so there was a question about the guardianship. Yes, the guardianship requires an annual report. Once a guardianship is in place, it requires an annual reporting to the court. And there's an investigation. The court that they send a court investigator to go check on the person to make sure that they're doing okay and reviewing the finances. They have to do an accounting. They have to submit an accounting of how the expenses were paid and things on that line. So yes, as it relates to there's court oversight, which is why as an attorney, right, I'm not saying that like you do hear of like bad situations, like you do, right, like they hit the news every so often about people who are in egregious kind of guardianship situations, and it's really hard to undo it, right? But that's not the case for a lot of people, right? You know, so for the most part, there is court oversight, and there's an accounting and a reporting to the court at least once a year that the person who is handling the affairs and handling the care of the person is doing right by their ward. Okay. So next is the advanced directive to physicians, and this is end of life planning. It is a very difficult document to for some people, because you're choosing what you want to happen in the event of two specific situations. One is a terminal condition. So this is defined as a condition where a person is expected to pass within 6 months, even with life-sustaining treatment. An example of this would be an aggressive stage 4 pancreatic cancer would be what a lot of people know of as being an aggressive cancer. So that would be kind of that type of a situation. And then for an irreversible condition, which is the condition itself is not terminal, but if there's not intervening life-sustaining treatment, it can be terminal. So that example would be a coma. So a person is in a coma. The coma in of itself is not terminal, but you need to provide nutrition and you know, for the person who's in the coma. Without nutrition, the person can pass from that, right? So that's an irreversible condition. In both of these situations, the choices are to let me pass peacefully, make me comfortable, but let me pass peacefully. And the second choice is use all life-sustaining treatment. If the choice is to use all life-sustaining treatment, you can put in additional instructions into that, right? So if you want to use life-sustaining treatment, but you're like, you know what, though, if I ever have to be put on a respirator, this is an example. If I have to ever be put on a respirator, then I want to be allowed to be passed peacefully. I don't ever want that to happen, right? And so that would be an example of that. And so what it does is it allows the person who will be being the one to enforce that end of life decision making, an understanding of what your request is. There is a third option in that you know you would have to look for a different template to do it, which is that you want your medical power of attorney to make the decision, and you would have to draft it in such a way where it's clear that that's what's happening, and so, but I will let you know though, as a general rule, the doctors don't make these decisions willy-nilly, right? Like they're not just like, oh, I got an advanced directive, I'm just going to automatically do whatever I think needs to be done. They always will contact the medical power of attorney. They will always call family before they implement whatever decision making is there. But this is a way to let people know what you want in advance. So it can be a difficult decision. If you have any question, if you have a current diagnosis that makes this document more relevant, you might want to have conversations with your physician to be able to know what they would, what these decisions may mean in when the doctor has to actually implement that decision if it ever comes up. Hopefully never. Okay. So those documents, disposition of remains, supported decision-making, declaration of a guardian, HIPAA release, and the advanced directive, those are the documents I think everyone should have, right? Like supported decision-making is kind of like 75%. I usually like the idea that if has people age, that they have that in place, especially if they've noticed a cognitive decline. So that one's an iffy, that one's a maybe. But otherwise, those are the documents that I kind of recommend and look at for everybody. So in addition, right, lots of documents. What are all the documents? We have a will, we have a statutory durable power of attorney, we have a medical power of attorney, disposition of remains, declaration of a guardian in benefit capacity, HIPAA release, and advanced directive. So 7 documents is what I typically recommend. The minimum: will, statutory power of attorney, and medical power of attorney. You may also, depending on your situation, may have a transfer on death deed and a motor vehicle designation. So so there's a lot of stuff and lots of things you got to think about. This last document, however, is very specific and to specific needs, which is a declaration for mental health treatment. These are for individuals who are at risk or have a history of psychiatric hospitalizations. And so a type of diagnosis where this may happen would be schizophrenia. You don't take your medication, you have capacity the entire time, you miss medication, and now you have a relapse and now you're going to be hospitalized for treatment for that. So this is a way for a person when they have capacity to make decisions about the type of care they will receive in the event of that hospitalization. It includes emergency treatment, types of medication, and types of specific treatment, including like seclusion and restriction and that types of things. It's not for everybody, but it's a very important document for those people who have this need. So if you know anyone or you yourself have one, you may not realize that this document is available. It's fairly new. I want to say like 6 years now it's been in effect, maybe 7. But it's really important. Unlike the other documents, every other document I mentioned, it's effective until you change it or revoke it, and you kind of need to update them when you have a change in your situation. A medical declaration for mental health treatment expires. It has to be re-executed every 3 years. Okay. All right, so now let's move on to long-term care planning. I don't spend a lot of time on this other than give you enough information to know that you need to be thinking about it. In and of itself can be its own hour and a half long presentation about long-term care planning. So what do I mean by this? We are living longer, has a general rule. And as we age, there is a possibility, and the stats are pretty high, majority of people will end up in some form of long-term care after a certain age. And so what does that mean? Residential homes, assisted living in some way, care coming in to our homes and taking care of us, right? And so that's what I mean by long-term care. It's typically medical in nature. And so what we are doing when it comes to long-term care planning is how do we protect our property when we go on to government benefits? And also, if we do have government benefits, how do we qualify for them and protect that for our heirs? We want our heirs to inherit the property, not the government to take our house, right? So that's what long-term care planning is. It's complicated and also not complicated. Very much depends on what's going on in your personal situation. So when you think about that, long-term care planning documents can include for your house and land, an enhanced life estate. That's commonly known as a ladybird deed. So if you've heard that, that's what it does. It's one of those things that is a way to protect your property to become eligible for Medicaid and to protect the property from what is known as the Medicaid Estate Recovery Program, MERP. And so there's that. But the same thing can be accomplished with a transfer on death deed. The same protection can do that. So remember, I told you about all of these individual situations. So now you're like, so there's potentially this problem here, right? Oh, well, I don't want my kids to go through the probate process, and I only want Susie to inherit my house. I want to do a transfer on death deed, and I'm going to give her the life insurance policy to pay for that. But this is a house that's not exempt. It's going to be considered part of my estate. And now there's going to be a potential MERP claim or something, right? Like, so you got to kind of, there's some puzzles, right? There's some pieces you got to put together to come up with the right plan going forward. So, but those are kind of the two documents that are typically used to be able to protect real property, houses and land from, to allow for qualification and to protect it from the MERP claim afterwards. For income. So sometimes people live together, husband and wife, spouses, right? There are spouses who live together. One of those spouses needs to get on Medicaid it needs to be qualified for Medicaid to get long-term care, but the other spouse is still working, and that income from that spouse that's working is sufficient, is enough to make the spouse that needs the care not qualified for Medicaid. And so what we look at that point in time is what is known as a qualified income trust, commonly known as a Miller Trust. You may have heard that language, and that is irrevocable. But what that does is that the income is now allowed to come into the household. It allows the person to become the one that needs the care to become eligible for Medicaid. And so that is something you do that. As I said, very individual, lots of puzzle pieces that may have to come in together. You should discuss it with an attorney on what the best path forward is if this is something that you need to be thinking about. Everyone should be thinking about it because, we work hard for our property, for our, and we want our heirs to get it. And so if there's a possibility of long-term care, we should be planning for it in such a way to try to protect the assets for our heirs. All right, I'm going to answer that question in a second. So what's next? We would need to be able to there's a little bit of work you need to do. So, which is to create a list of accounts, right? So, I just talked about a lot of things, right? Your financial accounts, your IRAs, your insurance plans, policies, your checking accounts, your debt, mortgage, reverse mortgage, credit cards, things like that, right? So you need to kind of put all that into place, right? Like, so that way your executor knows what you own, what you have, and what they need to take care of. And so, and then they will take that, all your estate planning your will and whatever documents they have, they're going to take your list of accounts that's going to explain what you got. They're going to take that to an attorney. Remember, you got to do something. And they're going to be like, hey, here's everything. This is what's going on. Here's what we're dealing with. And then the attorney can advise on what the next steps are and going forward with that. Be assured that your executor can access your digital assets, your phone. It's actually, we have had situations where we need court orders to get Apple to unlock a phone so that we can get access to the cryptocurrency that was only available via the app on the decedent's phone. That really did happen. And so you want to be sure that if there's digital assets, that that the executor is going to be able to get access to it and be able to disseminate it according to your instructions in the will or whatever other instructions they have been given. What do you do with the documents? Where do you keep it? What's a safe? You want to put it in a safe place. So you want to be sure all your documents are in a safe place. You're going to let the people who need to know where it is. So that's going to be your executor, the folks you name, and all of those other documents, right? You need to let them know where it is. Is it the safety deposit box? Maybe. Key thing that you need to remember, and this is something that Ms. Nia reminded me a while ago, now I always bring it in, which is that in order to get access to a safety deposit box, you need to be both an owner on the account and have a key in order to be able to get access to the safety deposit box. Otherwise, it requires a court order to open it, and it only can be the person that they expect to be the executor, and that's it, right? So that can be a little difficult for some people, so maybe not that. The county clerk, I get asked, do I have to file these documents with the county clerk? You can, but not required. So you can record it. That's fine. That's what it's called. You can record it with the county clerk where you reside. So that way there is an official copy of the will, but that's not necessary. It doesn't make it effective. It doesn't change its effectiveness. It's just a place to be able to get it if there's a need for it. But otherwise, my general recommendation is just put it in a safe place. Where's your passport? Where's your social security card, your birth certificates? Where are all these important papers? That's probably where you're going to want to include it. In my case, my family, we have a little safety file box that's like fireproof, right? That we can just grab that and leave in event of a hurricane. If we need to evacuate, that's where all of our stuff is, right? So that's probably what I would recommend. If it is coded, if there's a combination or something along that lines, be sure that the person who needs to get the documents knows what that is, right? And so that's what you're going to be able to do with your documents. But whatever makes sense for you and your family. I do always recommend that you keep the originals and you don't give the originals to someone else. But that, that's again, bad news, Jesse. I'm thinking about problems that might happen. So my recommendation is you keep the originals and then pass it on to the next folks. Then the last thing is you want to discuss things with your family. Have these conversations with both the heirs, the non-heirs, explain the decision making that was happening, have these conversations so that way nothing is caught off guard for them when they are able to do that. This is how you know that I have the wrong PowerPoint up. I have another PowerPoint that's a little bit more, everything's broken out a little bit. I covered all the information, don't worry. It's just a slightly different slides. But this is old, right? So obviously it's no longer March, but it says, Mr. Frosty, it's March. It's time to talk about estate planning. So don't get caught off guard by that. I also don't have a slide with all of our contact information. Again, this is a lot of information, and it can be overwhelming. And so, if you think that you can qualify for services, and I always say, don't worry if, don't think about whether or not you may or may not qualify, because a number of people do qualify for services. I would probably say if you're a millionaire, you don't qualify for services, but but some people will, and you can always apply for services. My contact information is right here. That's how you can apply for services with us. Ms. Nia is going to send you a list of all of our other partners that are available, that are part of the month of service collaboration, that that you can also apply for services with them. And then if you qualify, we can draft your documents for you and take a lot of the guessing out of it. But if you are a person who thinks that you will need to draft the documents yourself, you're not going to qualify, and so now you need to draft yourself, I invite you to come to part 2 of this presentation, which will be next month. We do it on a monthly basis. Next month, I will talk about how to draft your own documents, using Texas Supreme Court approved forms, to be able to draft your own will and your own transfer on death deed. And I will go through really in the weeds about what each document, what each section of the will needs to include, what each section of the transfer on death deed means. You'll be able to do that. Obviously, I only talked about things in a very big picture kind of way. We don't do this every month, but for those of you who are small business owners, people who, there's a lot, a lot of the businesses are actually small business owners. So if you're a small business owner and you got to think about your business, what's going to happen with your business, and that requires succession planning as well. And it may or may not be in your will. It depends on what's going on. We have a volunteer attorney, Ms. Botting, who's going to be doing that in a couple of weeks. So Ms. Dan is going to send that information. So if you know any small business owners who may or may not be thinking about how to handle their succession planning, please invite them to come to that session. And then again, if you came here because you were like, oh, I have a cloudy title, someone has passed what I do, don't forget, in a couple of weeks, my friend and colleague will also be presenting on the second side. I've just talked about the before. She's going to talk about the after in some degree. And so be aware to do that. And I think Nia is putting all of that into the chat. All right, with that, I am going to go back and find the one question, well, more than one question that I skipped. Let's see, where did I guardianship? Two owners of, okay, so we have a question, which is 2 owners of home. One passes, the living person has a TOD for their half. Does the other half go to probate? Yes. If the other person did not, if the other co-owner did not have a TOD, then I shouldn't say yes. It depends. And so if they didn't have a TOD, yes, the likelihood is that they may need to go through a probate process. There's ways to kind of handle property transfers without going through the probate process. They're not as there's not as much strength to them. But yes, typically if a person owns property and there is no will, or or there is a will, something has to happen to transfer the ownership of that interest in the property. Okay, let's see. I'm not sure if it's the right time to ask. I can answer that question. Technically not the right session, but it's an easy answer. So the question is that if spouses, one spouse inherits property from a parent or anywhere, like you can inherit it from anybody. If one spouse inherits property, are they required to share that with their spouse? No, inheritances are separate property. It does not matter, right? If you're married, you inherit a house, that is separate property. That's considered that person's ownership and things along that lines. And so, no, you can, that's up to you. Like, I'm not going to tell you, don't give it to your spouse if you want to give part of it to your spouse, but that's not the requirement. It's a choice made by the person who inherits the property. I will say this has a kind of very broad kind of an answer. Be careful, right? Because sometimes people will inherit either a house or money, things like that. Once there is sort of a commingling, like all of a sudden, like the community income is paying for the mortgage of the inherited property, or you put that $10,000 into the same joint account, there'd be a commingling happening there. It can get complicated. It can get messy. Like, well, what part is the community? What part is my separate property? And so technically, if there's worries about that, there may need to be a conversation with an attorney on how to best protect you, in that case, on how to keep it separated. So that way there does not end up being a claim on the inheritance because of that commingling thing. Okay. Do handwritten wills hold up? Do they need to be notarized? Okay. I did not talk about all the requirements for a will. I will do that next month, even though I will be talking about the forms. I do talk about what the requirements are in drafting a will. So handwritten wills are still legal. They have to be 100% in your own handwriting. They can be notarized. They're not required to be notarized. And so again, I didn't go too much detail on what the requirements are for a will. I'll do that next month. But typically for a will, a handwritten will just has to be 100% in your own handwriting. That's what makes it valid. A typed will, something you do on your computer, it prints it out, that requires your execution plus two witnesses to do that. The notary part is to make it self-proving, to make it easier to submit it into court. So that's a very fast answer to your question, but yes, they still hold up. They may be notarized, and I do recommend that they get notarized as self-proving when you're able to do so, because again, it makes the process and the probate side of things very easy. That starts going into that when I talk about like well-drafted, properly executed will, that's what we're starting to talk about, like, right? So, for those of you, but if that's all you can do is write a will, be sure you do it in your own handwriting. And I rather you have a handwritten will in your own handwriting than no will at all. If you file your docs with the county clerk, you probably don't need to keep looking at the snowman. If you file the documents with the county clerk, does it become public? No, it does not. Wills that are filed with the county clerk are not public information. And so now there is a possibility that once the probate begins, some people do have access to court records, but no one can find your will and be like, oh, I know Bob's going to get that house. Yoo-hoo, let's go marry Bob, right? No, that's not going to happen. September 4th, and then it's Nia's telling what things. All right, so someone says that they really need power of attorneys really quickly. The good news is that I believe, and because she does it almost every time, Nia's going to send you the templates of the documents. So with the power of attorney, those are actually, because they're statutory in nature, which means that the folks in Austin has already written what they need to look like, you can pretty much find them anywhere. Again, I have the wrong PowerPoint on here, but you can go to a website called texaslawhelp.org, and you can search for statutory durable power of attorney and medical power of attorney, and then it will take you to an online form that you can type in all your information and it automatically generates it. But you can also take the templates that Nia sends you and do that. So the good news is that you don't have to do a lot. They both need to be notarized though, so be sure you take it to a notary to get it notarized. Or you can apply for services, but if it's urgent and like I would say if it's urgent, like there's a need for it, then go get those done and then apply for services to get the other 5 documents. That's it. Any questions that you're seeing, Nia, on the other side of things?
I was just copying. Hold on, let me close this up because I'm getting the feedback on my end. Close. Okay. I was copying the information for Texas Law Help so I can put it in the chat here for the guided forms, and you can just go and find the form and fill it out there. But again, any of the documents that Jesse went over today in regards to the will, the holographic will, all those are the documents that I am going to be sending out you copies of the templates of. And then next month she'll go over how to draft your own will and Todd. There was the one question in here. I can't remember if you had gone over that or not. That if it was something about the Todd. If there's a Todd in place and the home is not paid for, what happens? Did you go over that?
Oh, yes, debt. I did talk about debt. So if there's a TOD in place, the person who inherits the property has to figure out how to make sure to continue to pay that, right? So if you're a person if your estate will have the funds to cover it, then you can kind of plan for that. But otherwise, the beneficiary will have to kind of go talk to the bank, see what they were willing to do. Some banks will allow you to assume the loan, like no changes, right? Like, okay, that's fine. We'll just, keep doing it that way. Some will require new financing, right? And usually my understanding is, I'm not a banker, can't speak on bankers, but where we have seen where there's an assumption where they kind of let you stay on is when when the beneficiary is already on the loan. But if you're not on the loan and the beneficiary is new, they will require refinancing. Like you won't be able to just step in because because they're gonna need the assurances they can sue you if they need to foreclose.
In addition to that, sometimes they still just won't even talk to you, period. So
Yeah.
I've had some clients, because I'm a realtor also, that that once they've gotten a mortgage, even though they're the only people that are on the mortgage, that they'll still call and leave this person's name or contact or a reference to say, in the event, you're allowed to talk to this person about my account or what have you. So they can do that as well too. But
Mhm.
otherwise, as long as you're making the payment, they don't really, most times they don't really care. But if you need to call and say, hey, I'm running into a financial difficulty and I need to make some arrangements, they won't do that with you.
Yeah.
Uh, let's see.
It's
Majority of
usually
the,
better to refinance. Like honestly, it's better to refinance than
yeah.
beneficiaries to do that because it prevents a lot of problems or makes it easier to handle problems that do come up.
The majority of the other questions that were being sent prior to were about trust, and you kind of went over those already, so I won't get into the detail of those questions since a couple of the
Yeah,
questions
I
were
actually
really
didn't talk very
detailed.
much about trust because it's the wrong PowerPoint. This is
Uh,
the PowerPoint y'all got today was my in-person 1 hour session, not my 2 hour session. So that was the mistake. Although I did cover everything I normally talk about. So trust, talk to an attorney about that. So anyone who's thinking, oh, I want to trust, I will say that there are reasons to have a trust, but if the reason why you want to do a trust is because you're trying to avoid probate, that's the most common thing that you see like on these national sites and TikTok and things like that. It's like, don't do a will, do a trust, right? Yes and no, right? It actually doesn't solve all the problems you think it's going to solve, right? It's not, you're just moving the work. Like, right? A trust is just moving the work to while you're alive, to while before you pass. They can be more expensive than a probate, depending on the kind of trust that you're doing. So I always recommend that you talk to an attorney if you think you need a trust, because there are reasons for one. And then make the best path plan for your individual plan, whether it's a will. Oh, by the way, even if you have a trust, you still need a will, like, right? So, yeah, you would still need to talk to somebody about what's the best path forward.
do. Okay, somebody that's currently going through probate. We're going to be going over the small estate affidavits next week in the inherited property and probate concerns presentation next Thursday. That one is at 1 p.m.
Mhm.
So I won't get into that. Okay, so the majority of everything else that was asked that's related to the advanced legal planning, you pretty much covered. Um, with a Paul Bird, since I have a question. Do you want to unmute yourself and ask the question, or do you want to type it?
Hey guys, thank you so much. This is Regina and Paul Burks.
Okay.
We have a question regarding we have a family member that his home was well, he recently passed away, and his home was fixed by the city of Houston. So he does have like an outstanding balance on the city of Houston home, which has been our family home. And it feels really confusing. What are our options? I heard you
So,
say that a lot of times the finance company will just say, okay, um, whoever's gonna pay for it, just go for it, and pay it and the loan and keep the house. So
Right.
That's different for those programs that are like that through like the city of Houston. They have what's called an affordability period. So you generally, would have to own and occupy in order for you not to have to pay the money back before you could transfer it, sell it, and so on and so forth. So you would basically have to review the documents that he signed to see what exactly was that affordability period and what the restrictions are, because we don't know. So if you're not sure, or don't know where those documents are, then I would definitely recommend contacting the City of Houston Housing and Community Development Department. If it was City of Houston, or if it was Harris County Housing and Community Development, contact them directly and explain to them that someone has passed, that have gone through their program with their house being renovated and so on, and see what they tell you, what the process is, because we wouldn't be able to tell you one way or another without knowing what those documents say.
Right,
What-
and that is what we're going through, because we don't know where to go and get those documents. Yeah,
Yeah.
so you just gave us some information there. Thank you.
Okay. Was there anything else for anybody else? I don't think so. But again, the links and the resources that were also referenced, upcoming dates and the calendar, all of those things will be submitted or provided to you all. Hey, Ms. Patterson, glad you were able to join. Okay, I will be at the next one. For some reason, not receiving the emails on the recent ones. Okay, I will definitely make sure that you get added so that you can get the notifications for upcoming presentations.
Thank
Ms.
you.
Kenny, you're welcome. Ms. Kenny, your hand is up. You have a question?
Can you hear me?
Yes, ma'am.
I had sent you a message directly to you, but I don't know that you saw it.
Oh, you know what? See, Zoom rearranges some stuff around here, so I didn't. Okay, now I see. Is there another means to? Okay, so when you review the record, the session itself is being recorded. I will be sending out a link of the recording so that you can go back and watch this whole presentation. It'll also have all of the notes there. In addition to that, you can go to our YouTube channels and watch the recordings there as well. So I'll include the link for the YouTube page on the email that gets sent out too.
Am I allowed to share that with my son and daughter-in-law so they are
Absolutely.
aware of
Yes.
where I'm coming from?
Absolutely, absolutely, absolutely. We even ask you to tell them to come to one of the sessions if you all want to sit up, because we've had a few people that even just sit around the screen with their family members and watch it too. So it's like they're watching a Monday afternoon special or something. But
Oh, no, yeah, I'm going to visit. So maybe if I have it on this weekend, so maybe if I have the recording, we'll sit and watch it together.
it'll take it about an hour for it to finish cycling and processing or whatever, and then it gets sent out. So you'll have it this afternoon.
Thank you so much.
You're very welcome. Miss Carter. Please add my. I did sign up for the interest. Okay, we'll make sure that you get your Miss Carter the notifications as well. Okay, I believe that is all that we have, Justin. We did get through that one pretty fast, huh?
I know. I was like, as soon as I realized, I'm like, oh shoot, I had to remember everything I talked about.
Well,
but,
that's quite all
I
right. It still
appreciate
was a lot.
everyone. I promise you got everything, and I appreciate everyone's time. So have enjoy the rest of your day and have a good evening.
All right. Thank y'all very much for attending. Again, the recording will go out, the resources will go out, the templates will go out. You guys are more than willing to come back, or more than welcome to come back and attend next month's session when Jesse goes over reviewing how to create and draft your own will and transfer on death deed, and how to get those things executed and so on and so forth. There are other, let's see, what do we have? This Saturday, we have our first time homebuyer education class that's coming up. Again, next Tuesday, we've got the estate planning essentials for small business owners. That's going to be coming up. Next Thursday, we've got the other session of what happens after the clearing title for inherited properties and other probate concerns. So you definitely want to join in for that to find out what happens on the back end of things after someone actually passes. So this is the preemptive, what happens, what needs to be done before, and then we're getting to the after, what happens after someone passes. So so definitely join us for that. Once you guys in this session as well, you're going to get the little survey box that pop up. We ask that you please take a moment to complete the survey. Just let us know, hey, you got the information you intended to receive. Was there some information that was missing, something else that you wanted us to go over? Or if there's some session that we don't currently offer that you guys need more information about or want information about, to say, hey, this is going on. This is what's impacting my family right now. This is what's going on in my neighborhood right now. Do you have any information about this? Or can you share or provide or get us some kind of resource or something for this? Then please just feel free to let us know. And help us provide your input, because that's how we plan and schedule all of our meetings going forward as well. So I believe that is it. Thank you all very much for joining us. We hope you all have a wonderful remainder of your afternoon. Continue to take care of yourselves. Stay safe. Miss Leticia, thank you very much for
Oh,
joining.
that's what I was gonna say. Thank you all so much. Y'all are just the best. I actually
Thank you.
am here with my dad. I want to try to help community and other people as much as possible to be introduced to you guys. And it is a wealth of information, but thank God we can play it back when we can get to it and those types of things. Thank you for
Mhm.
educating us the way you all do.
Thank y'all very much. And again, we're going to try to see about scheduling and trying to get out there and doing some more hybrid kind of things. So,
Beautiful.
but it's a matter of us finding locations and logistics and making sure that we got staff people or volunteers or somebody to cover. So even if we can get multiple locations going at the same time, if you've got a church
Wow.
group or something like that that's
Oh,
willing
that's a
to
good
do an
idea.
on-screen thing that we can come in and help you guys set it up so that you'll know how to do it every week, please let
Yes.
us help you guys do that, because we want to try to get as many people to get this information as we possibly can. And maybe we can get little viewing centers showing up all at the same time. You guys turn your cameras on and we can see everybody in multiple locations watching, joining in, make it a little watch party or something. So
That
Jesse,
is
you'll
an
be a celebrity
awesome
in no
vision.
time.
Yes, thank you for that idea. I'll be looking into that, and definitely if it's something works out, I will love to get back with you guys with that.
Okay, absolutely. Thank y'all
Take
very
care.
much. Hey, Miss Paulette, I'll see you up there too. Thank y'all for joining. You all have a wonderful remainder of your afternoon. Stay safe, and we'll see y'all next time.
And a great program. Both the presentation was fantastic.
Thank
Thank
you,
you,
thank
Ms.
you.
Campbell. Thank you, Nia. It was great. Keep up
Thank you,
the
Miss
good work.
Paulette.
Oh, thank
Hey,
you.
Miss Andrea, how are you doing? Miss Carter's here. I saw Tina pop in too. Tina used to be on here a long time ago.
I'm wonderful. I
Good to have you.
enjoyed this so much.
Thank you.
This
Thank
was
you. Thank
very, very, very educational for me. And I thought I was
Good.
covered with a few documents I have, but I find out I'm have to do my homework all over again. I have a deed of trust, a living trust. That's what I have. But now I see I need to do the DODD. I need to take care of some stuff because I was unaware that the 50-50. And we have a situation that I need to take care of the 50-50 right away.
Okay, good deal. All right, we'll see y'all later.
Don't forget to send me the links and everything. Include me in everything. This is my first time, and I thank y'all. You all were wonderful. Thank you.
Okay, we definitely will do. Thank you very much.
Okay.
All right.
Thank you.